let's hear appellant's position on the next charge.
May it please the court, Latasha Richardson representing minor child CC. My client was charged with a violation of Penal Code 502c3, unauthorized access of a computer. My client, a 14-year-old child, vehemently contends that there was no evidence put forth by the people, and the facts will show that no crime has been committed because my client obtained full consent to access and use the computer by the school, which is a valid affirmative defense. Therefore, the probation sentence imposed by the juvenile court should be overturned. CC's juvenile record should be sealed until his 18th birthday and then expunged. The people have the court entangled with a term of art with the word knowingly. The legislature did not apply a definition to the word knowingly because it is wildly subjective, highly fact-specific, and driven, and there are far too many variables to create a one-size-fits-all definition.
But how is the word knowingly vague and incredibly subjective? Doesn't that just mean that he knew what he was doing?
No, Your Honor, I don't think so. What I'm saying about the word knowingly, it's going to depend. It's going to depend, are we talking about someone who's incompetent? Are we going to talk about someone who's a child? Are we going to talk about someone who's an adult? That is subjective. And what do they know? And how do they know it? We have not received, the defense has no evidence that there was ever a school technology use policy given to the child or his parent or guardian. So we don't even know if what was proffered was authentic.
But counsel, isn't there evidence in the record where your client conceded that he knew what he was doing was something he wasn't supposed to be doing?
When you say conceded, I'm not sure that I recall seeing that in the record. However, I will say this, that my client did say that he knew he was not supposed to be anywhere other than on the Desmos program. So we're going to talk about...
Why is that not knowingly?
Well, does knowingly equal misuse? Does misuse equal mistake? So,
well, misuse might be related to the without permission prong. So why don't we talk about that?
Okay. So without the permission, we don't have that. When you say without permission, that means that no one granted you access. We know that the minor child here had a user ID and a password. He had access to get into the computer. We do know that he was given that access by the school. That's the only way he could have gotten it. So there is consent there. Now, if we want to talk about, the fact that he may have ventured off to another website, that's a different issue. That's not this issue, though.
Counsel, what would be could you provide the court with an example of what you would characterize as knowingly and without permission? What conduct would constitute a violation of the statute?
Well, how much does a person know? I mean, the case that I looked at was Chrisman v. City of Los Angeles Police Department, and that's 2007, and that's in the 2nd District, Division 8. And in that case, the accused was a police officer, and he was using the computer to access people's addresses and phone numbers. And the court in that case, they opined and they said, no, there's no way that this was unauthorized use because he had use to get into the computer. If he did not have authorization, then that would be something different. That would be like hacking, or that would be like extracting data. Where is the criminality here?
Was that a criminal case?
I'm sorry?
Is Chrisman versus LAPD, is that a criminal case?
That is not a criminal case, but it was the closest case that I could find that was on point and similar to the facts in this case.
And what language was at issue in the Chrisman case? What statutory language were they interpreting?
They were interpreting the with permission, without permission, unauthorized use.
Well, from where? What's the statute, or where did that language come from?
From Penal Code 502c3.
Oh, so even though it wasn't a criminal case, they were still interpreting the same penal code statute that we're addressing today.
Yes, Your Honor, that is correct. And if I may, The court further stated, underscoring that accessing a computer's logical, arithmetical, or memory function is different from ordinary everyday use of a computer to which people are accustomed when they say or speak of using a computer. And so one reasonably cannot describe this child's improper computer inquiries as hacking, because the court in the Christman case observed that every state has some sort of prohibition against accessing a computer system or network without authorization and unauthorized access that results in the commission of some further criminal activity, such as copying or destroying data and aggravated hacking or cracking. The proscriptions of simple hacking are substantively consistent. These statutes almost unanimously outlaw the act of gaining unauthorized access. Here in this case, we do not have hacking, cracking, copying, or destruction of data, nor do we have computer trespass. It is undisputed that this child was in the possession of a login and user password, which he used to gain access to the computer's internet browser, which was issued by the school. And, this is a public policy issue, Your Honors. And because the school's disapproval of a student's conduct, it doesn't cast the conduct outside of the school use. If the school's disapproval were the measure, then any misstep, mistake, or misconduct by a student involving a school's computer by the school's reasoning would be rendered criminal. And the school does not get to make or prosecute a violation of an alleged violation of law. Roseville High School could have implemented safeguards, and they could have put in firewalls. They could have had keyword blocking. They want this 14-year-old child to take the blame for their negligence. And the school has a duty to ensure the safety, and that means putting preventive measures in place. We shouldn't be here. This is not a case that should have even been prosecuted because we don't have any evidence. I have yet to see the computer. Where is it? We've not seen an asset tag number. We have nothing to substantiate that a crime had been committed. How do you use a school shooting simulator? What is the definition of a school shooting simulator? I have no idea, and the people have not given us those tools. So we don't know why we're here. But we want to make sure that we help this child and we get him into a better position and not this station in life.
Thank you, counsel.
Thank you.